In 5, 4, 3, 2.
Your Honors, good afternoon.
Yes, good afternoon.
This is a continuation of the public panel interview of candidates for the position of Associate Justice of the Supreme Court, Vice the Honorable Justice Priscilla J. Baltazar-Padilla. The candidates for interview this afternoon, Your Honors, will be the following. Presiding Justice Amparo Kabutahe-Tang of Sandigan Bayan, and Court of Appeals Justice Japar B. Dimaampao. May I request the candidates to please raise your right hand so that I can administer your oath? Do you swear to tell the truth, the whole truth, and nothing but the truth in this public panel interview by the Judicial and Bar Council?
Yes, I do.
So help you God. Thank you. Your Honors, the first candidate for interview will be Sandigan Bayan Presiding Justice Amparo Kabutahe-Tang. And the first to interview the candidate will be the Honorable Justice Noel Jimenez Tijan.
Thank you.
Welcome, sir.
Thank you, Attorney Ed. Good
Welcome, sir.
afternoon, PJ Ampi.
Good afternoon, Justice.
Isn't it that we just interviewed you recently? When was the last time we interviewed you?
Last May po.
May. This year.
May of 2020, Your Honor.
2020. So within 1 year. Correct?
Yes po, but I think it was not a public interview, but it was a dry run, Your Honors.
Oh, a dry run. Yeah, because I distinctly remember that we interviewed you. I forgot that it was a dry run. All right, PJ Ampi. One of the questions asked in the essay was the question on judicial independence. So, what again is your understanding of judicial independence?
Your Honors, if I recall correctly, my answer yesterday is freedom from outside interference in the resolution of cases. Freedom from interference in the resolution of cases. It is not being swayed by factors, whether internal or external, in the resolution of cases, and that cases must only be decided exclusively based on the law and the evidence before me or before the court.
Now, a correlative question was, in your opinion, is the filing of an impeachment complaint against a Supreme Court magistrate, does it constitute a threat, an impairment of judicial independence?
My submission, Your Honor, is that it does not impair the independence of the judiciary. After all, this is a mechanism that is recognized no less by the Constitution. It is a mechanism whereby a member of the Supreme Court who is found to be unfit to remain in office is removed.
In the first place, it is a mechanism
Recognized no less by the Constitution.
placed by the framers in the Constitution, correct?
Yes, Your Honor.
And I don't think the framers intended that mechanism to impair judicial independence. Now, the city government of Baguio recently announced an anti-road obstruction campaign, and they banned newsstand in sidewalks. You're familiar with Baguio. So
Yes,
they banned newsstands located in sidewalks because they considered them as eyesores. Now, the Baguio Correspondents and Broadcasters Club, BCBC, opposed the move, claiming that newspaper vendors operating the newsstands contribute to the delivery of news and information to the people. As a magistrate, in your opinion, what are the legal and constitutional issues involved here? And the correlative question is, if this reaches the Supreme Court, how would you resolve the case?
Well, given the claim of the newspaper publishers, Your Honor,
Yes, yes.
so therefore it will go down to the question of whether such a prohibition would result or will result in the impairment of the freedom of the press or a freedom of information to disseminate as a as a uh, as a uh, as a means to disseminate information, Your Honor.
How would you resolve the case as a magistrate? By balancing, do you think that there is also a primordial interest on the part of the city government of Baguio?
Yes, Your Honor. It does also have an interest to see to it that its city uh, retains its aesthetic value. That means it continues to be a a tourist spot for its for visitors who might be minded to visit it, and thereby with it will actually improve or enhance the economy of Baguio by being able to encourage or attract more tourists to the city, Your Honor.
So, how would you resolve the case, in your opinion?
I
Will
will
you sustain the ordinance of the city of Baguio prohibiting or disallowing newsstand to be placed in sidewalks because they remain as eyesores. And this is pursuant to an anti-road obstruction campaign.
I
Or will you sustain the oppositor,
yes,
the petitioners, the Baguio Correspondents and Broadcasters Club, claiming press freedom?
I will sustain, Your Honors, the Baguio City Ordinance. After all, since it is on a sidewalk, the city has every right to see to it that there will be no obstruction and there will be free uh, 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 the people who might be minded to walk along the sidewalk will be completely unobstructed or unimpeded in their in walking through those sidewalks.
Where will the residents of Baguio buy the newspapers?
Well, there can be perhaps the city can provide some spaces where these newspapers can be appropriately and properly distributed, Your Honors.
Because the store owners will not allow the newsstands to be installed inside their stores because it will also affect their business, correct?
Yes, Your Honors. But the city of Baguio, perhaps Your Honors can offer some free spaces for these vendors where they could sell this these newspapers, Your Honors.
So what will be your constitutional justification for allowing the city of Baguio
That
to
will be
enforce the ordinance?
I will base it on the police power of the city government, Your Honors.
And that is, in your opinion, that is more paramount than the constitutional freedom of the press?
Yes, Your Honors. Because as
Safety, are you saying police power to ensure the safety of residents? You're saying about that? Because they constitute obstructions in
yes,
the.
Your Honors. Yes, Your Honors. Because as decided in several cases by the Supreme Court, the police power of the state, which is one of the inherent powers of the state, is the least limitable and the most pervasive. And it can actually intrude in any activity of any individual for as long as there is a no violation of the right to due process.
Now let's talk about the vaccine. If the vaccine is already available and approved by the FDA, should it be made mandatory, compulsory?
My take is that, Your Honors, it cannot be made compulsory.
Cannot be made compulsory.
Yes, Your Honor.
Why not? Is public health not a principal concern of government and of society itself?
Of course, it is, Your Honors, but this is an individual choice. It's a freedom to choose whether to be inoculated with this vaccine or not.
So what is the rationale in compelling the wearing of a mask and the wearing of a face shield, and yet you're saying it's a matter of personal a freedom of choice that you will not compel people to undergo vaccination? What's the difference?
Because, Your Honors, not wearing a mask or the face shield could easily transfer the virus. The purpose of inoculation simply is to get the individual who is inoculated at least immune from contracting the virus.
So if there is a regulation by government mandating compulsory vaccination, you would consider it unconstitutional.
Yes, Your Honor, I will.
Constitution.
I take that, Your Honors.
It was reported in world news that Spain announced that it will set up a registry of people who refuse to be vaccinated against COVID-19. And that registry, they will share it with other European countries. Now, if the same regulation is adopted in the Philippines, mandating a registration of people who opted to exercise personal choice, who opted not to be vaccinated, will that be valid? Will that be legal? Because you said it cannot be made mandatory, okay?
Yes.
It's a matter of personal choice, but can government make up a list of people who refuse to be vaccinated so that they have a database so that they can share it with other government agencies as well and with other countries, so that if somebody, a Filipino or a resident from the Philippines, travels abroad, then that kind of information is shared with the foreign countries. Will that be a valid regulation?
Yes, Your Honor, because it is simply a listing of those people who have not opted to be vaccinated, Your Honor.
In the budget recently approved, passed by Congress and approved by the President, there was this issue about intelligence funds. And if I recall correctly, there was a vetoed provision that would require the Office of the President to disclose how intelligence funds are defrayed or spent. And the Office of the President objected to that. So my question is, are intelligence funds related to national security of the Office of the President subject to the oversight powers of Congress?
I respectfully submit, Your Honors, that it is not subject to the oversight functions of Congress.
What is your understanding of oversight powers of Congress?
It is the power of Congress to see to it that the legislation that it has enacted has been properly implemented by the executive branch of government, Your Honors.
So how do they exercise oversight powers?
They they can call a um, a hearing, Your Honor, uh, and request the cabinet secretaries to make reports regarding implementation of these laws that they're tasked to implement.
Now, Congress passed the anti-terror bill, and the executive department, through the Department of Justice, promulgated internal rules and regulations, IRR. Should the IRR be submitted to Congress for information and review as part of the oversight powers of Congress?
Uh, my understanding, Your Honors, is that there is no need for the submission of these IRRs because this a law like this anti-terror law authorizes the agency concerned to implement its rules and regulations consistent with the purpose and objective of the law.
But isn't it that oversight presupposes monitoring that the law is followed by government agencies?
Yes, Your Honors, but I don't believe that it is mandatory. But the of course the DOJ can opt to submit a copy to Congress, Your Honors.
Yes, precisely. They can submit a copy to Congress.
Yes.
Can Congress make comments on the copy of the IRR furnished to them for information in the exercise of their oversight powers?
No, Your Honors, because under the anti-terror law, it's the Anti-Terrorism Council that is duly empowered to promulgate these rules and regulations.
But the Anti-Terrorism Council is part of the executive department, isn't it?
Yes, Your Honors.
So how will Congress monitor the strict compliance with the law if they cannot make comments on the IRR of the anti-terror law?
Well, I'll change my answer, Your Honors. It can make comments, but it cannot compel the DOJ to act in a particular way because that is within the power of the Anti-Terrorism Council. Perhaps with those comments coming from the Congress, the ATC can modify or amend some of the provisions found there, which will better serve the objective and purposes of the law.
Let's go to another topic, sexual harassment. Is your understanding of sexual harassment based on gender?
No, Your Honors. I think the Supreme Court very recently has decided a labor case, where the Supreme Court said that sexual harassment is not about gender, but it is about abuse of power.
So even male persons can be victims of sexual harassment.
Yes, Your Honors. That is the very case I am referring to, Your Honors. He was a seaman, and he was subjected to sexual harassment by the chief officer of the ship that he was in. He also threatened to cause him harm if he did not do these things that he wanted him to perform.
So it's a reality that either members of either sex can be the victims of sexual harassment, of discrimination. That's a reality, correct?
Yes, Your Honor, that's correct.
So should there be a counterpart of the VAUSI law as well to cover the male members of society if they are if they are the victims of sexual harassment as well, or psychological violence?
Well, maybe that is something that Congress uh, can ponder upon, Your Honors, on whether men should already be included also as possible victims of under the anti-VAUSI law, Your Honors.
If a case is elevated to the Supreme Court and you are in the Supreme Court, and the issue is a particular law which you find to be unconstitutional, should you point it out, even if the issue of constitutionality was not raised in that petition, and the relief sought is something else? Can you, in other words, can a magistrate sua sponte on its own accord act on the unconstitutionality of a law, even if it was not raised in the very case elevated to the Supreme Court?
Uh, no, Your Honors, because again, there are requisites before the Supreme Court may exercise its power of judicial review. And if the issue is not, the constitutional issue is not directly and actually presented, that constitutional question must not be passed upon.
Is it your understanding that if a case is of transcendental importance, the Supreme Court has no choice but to decide it and even resolve factual issues? Is that your understanding?
No, Your Honors, because in the case of Gio Samar, the Supreme Court there, through Justice Hardeleza, said that while the issue raised may be one of transcendental importance, this should be coupled with the fact that there are no factual matters raised.
As by way of first impression, as far as the petitions against the anti-terror law is concerned, are you absolutely sure that there are no factual issues raised?
Your Honors, I have not, honestly, I have not read any of the petitions filed before the Supreme Court regarding the anti-terror law.
You must have some idea based on what you read in the news, the questions regarding the anti-terror law. Are you absolutely sure that only questions of law are being raised by the petitioners?
I'm not sure, Your Honors.
All right. What about the president's power to grant pardon? Is it absolute?
Your Honors, it is absolute, but it is the only constitutional limitation here is that it must be extended only after the decision or judgment of conviction shall have become final and executory. And in case of election offenses, the same may be granted upon recommendation of the Commission on Elections.
So a pardon cannot be issued by the president for cases being investigated for future crimes. It cannot be.
No, I don't know, Your Honors, because the Constitution is very explicit on when the president may extend pardon.
Is it subject to judicial review? The exercise by the president of the power to pardon, is it subject to judicial review?
No, Your Honors, it's not subject to judicial review unless, again, it was extended prematurely. That is, it does not comply with the constitutional requirement that it must only be extended once the judgment of conviction shall have become final and executory.
Can the president, before he ends his term, pardon himself?
No, Your Honors, because again, there will be no compliance with the constitutional requirement.
So you're saying there should be conviction?
Yes, Your Honors.
Absolutely conviction.
Yes, Your Honors.
What about impeachment cases? Are they subject to pardon?
No, Your Honors. The Constitution, again, is very explicit here. Except in cases of impeachment, the President may grant pardon, reprieves, or commutation. That's the language of the Constitution, Your Honors.
What is the doctrine of qualified political agency?
Well,
PJ.
this doctrine teaches that the cabinet secretaries are the alter egos of the president. So their actions carry the presumptive approval of the president, and unless reprobated by the president, they are presumed to be the acts of the president, Your Honors.
Can the president delegate the authority to pardon prisoners under the doctrine of qualified political agency?
No, Your Honors, because based on case laws, pardon is a private act of the president, and he alone can extend this pursuant again to the Constitution.
In the United States, we have the Boy Scouts and we have the Girl Scouts. Are organizations limiting membership to boys and girls discriminatory?
No, Your Honors, because these are these are organizations where membership may be limited to a certain group of individuals.
Is it constitutionally permissible for government to allow the Boy Scouts and the Girl Scouts to give up their single-sex status and admit boys and girls who claim that they are transgenders? Is it constitutionally permissible? So the Boy Scouts allowing transgenders to join them, the Girl Scouts allowing transgenders to join them. Is that constitutionally permissible, or is it discriminatory?
I don't believe, Your Honors, that it is discriminatory.
Why not?
Because this is an
So
organization.
there's nothing wrong for the Boy Scouts to allow transgenders who feel that they are males or who feel that they're boys, and for the Girl Scouts to admit in its membership transgenders who feel that they're women or they're girls. There's nothing wrong with that.
Yes, Your Honors, because these organizations have the freedom to choose who their members would be.
Does it not violate the Equal Protection Clause?
I don't believe so, Your Honors, because as organizations, they are not regulated by government. I mean, in that context,
Are they covered by the Constitution? If somebody would like to join the Rotary Club of Manila, for example, and he is denied membership, can he go to court and claim discrimination?
no, Your Honors, I don't believe that will be discriminatory.
Why not?
Especially it's a private organization, it has the absolute freedom to choose or select who its members may be or could be, Your Honors.
What do you understand, PJ MP, of the Syracuse principles? Have you read about it?
Honestly, no, Your Honors.
Are human rights absolute, in your opinion? Or in other words, if I may phrase it differently, can human rights be regulated or restricted?
Yes, Your Honors, the exercise of the human rights. Because as taught, every right has a corresponding obligation. So rights may be regulated to a certain extent, Your Honors.
A quarantine. What is the basis for a quarantine? Are human rights restricted or regulated during a quarantine or a lockdown?
Yes, Your Honors, because quarantine requires the isolation of the person within a certain period of time. Normally, it's 14 days, and therefore, there is a restriction of the freedom of movement.
So you just read the Syracuse principle under the International Covenant on Civil and Political Rights. That's very important.
Yes, Your Honor.
Yesterday, I went to the mall and I was denied entry because they only allow people between the ages of 18 to 65. I overshot the age limit. So my question is there constitutional and scientific basis for that kind of protocol?
Well, I think that is an IATF guideline, Your Honor. And
If it is questioned before the Supreme Court and you are in the Supreme Court, how will you decide that case?
well, Your Honors, I was also not accepted in one of the hotels because of my age, because of my age. And
Is that not discriminatory? As a magistrate, not as a person, but as a magistrate, is there constitutional basis for restricting the entry of people below 18 and above 65? And why 65? Is that not arbitrary? Is there a scientific legal basis for pegging it at 65? So with that protocol, even the Chief Justice cannot enter public places.
Your Honors, from what I watch or hear from the news, persons of these ages are more vulnerable to contract this COVID-19, Your Honors. And I believe this is consonant. The prohibition on the entry of certain age groups is consistent with the constitutional requirement, constitutional. It can be based constitutionally on the right to protect public health, Your Honors.
Now, my last question is, you're 66 years old. If you're nominated and you're appointed to the Supreme Court, what will you attempt to accomplish during the first year? Will you be merely observing and listening to the oral arguments or the deliberations?
No, Your Honors, the first thing that I would do is to make an inventory of my docket and decide as speedily as possible without, of course, sacrificing the substance of any decision.
Is it important for the public to know what cases are decided by the Supreme Court on a monthly basis, in your opinion?
Well, yes, Your Honor, consistent with the public's right to information. I don't believe there is anything wrong with making public the accomplishment of the justices, Your Honors.
In the United States Supreme Court, they decided a landmark case, the case of the Archdiocese of New York versus Governor Cuomo, nullifying government regulation limiting the number of participants inside a church and inside a mosque in New York. So that's a landmark case. They already decided it. Now, there are similar petitions pending before the Court of Appeals in the United States, and which are elevated to this, which are bound to be elevated to the Supreme Court, and the SCOTUS, Supreme Court of the United States, instead of acting on it, merely issued a resolution directing the Court of Appeals to resolve it in accordance with the decision in that landmark case. Is that something which can be done by the Philippine Supreme Court? In other words, if there is a landmark case that sets standards, sets the guidelines, there is no more need for similar cases to be elevated to the Supreme Court, which are still pending. If it is elevated, it should not act on it and merely direct the Court of Appeals to decide the case in accordance with prevailing jurisprudence. Is that something, in your opinion, can be done by the Supreme Court?
I don't believe so, Your Honors.
So it's still important that you have to act on each and every case that is elevated to the Supreme Court.
Yes, Your Honors, because
the Supreme Court is the final arbiter.
yes, the court of last resort.
In other words, nobody should follow a decision unless the Supreme Court has given its imprimatur. That is what you're saying?
Yes, Your Honors, because after all,
So what happened to
only the decisions of the
what
Supreme
happened
Court.
to Gio Summer, penned by Justice Ardilesa?
No, but the issue there, Your Honors, is about the
When you say hierarchy, of course,
hierarchy
it's
of
important for everything, even ejectment cases, to reach the Supreme Court. And people will not follow it unless it has the imprimatur of a Supreme Court, of the Supreme Court. Is that what you're saying?
No, Your Honors, only with respect to cases that involve constitutional questions. But other than cases which involve issues other than constitutional issues, perhaps the Supreme Court.
Ejectment cases also reaches the Supreme Court, isn't it? Collection cases even reaches the Supreme Court.
Yes, Your Honor. But,
So are you saying that the public should accept the fact that only decisions with the Supreme Court imprimatur should be considered binding? That decisions by the appellate courts, including the Sandigan Bayan, including the Court of Appeals, including the Court of Tax Appeals, will have no bearing, will have no binding effect unless it is affirmed by the Supreme Court, because the Supreme Court is the final arbiter. Is that what you're saying?
yes, Your Honors, because only decisions of the Supreme Court form part of the laws of the land. And
So
unless the
that's an
Supreme Court
argument
is spoken,
against- That is an argument in favor of congesting the court docket, correct? All right,
yes, Your Honor.
EJ Ampi, thank you for your time and good luck.
Thank you, Your Honor.
Thank you, Your Honor, Justice Tiham. It is now the turn of Honorable Judge Toribio E. Ilaw Jr. to propound questions to Honorable Sandigan Bayan Presiding Justice Cabotaje Tang. Your Honor, Judge Ilaw, please.
Yes, thank you, Attorney Ann.
Welcome, Your Honor.
And sorry. Yes, good afternoon, the Presiding Justice,
Good afternoon, Justice.
Cabotaje Tang Amparo, simply to be called Ampi.
Good
How are you
afternoon.
today? How are you today?
I'm fine, thank you, Judge.
Frankly, I'm really hesitant and unwilling to ask questions because we had previously interviewed you for how many years? Starting on December 5, 2018, that is for Associate Justice of the Supreme Court, except for January 7, 2016, when I was not yet a member of the JBC. So I was privy to it starting on December 5, 2018, June 25, 2019, September 10, 2019. And lastly, according to you, you appeared also before the JBC on sometime in May 2020, but not for an interview.
I was
Just according to you, a dry run.
It was not
That
public.
is during the time. Yes. Yes, Justice.
Yes,
Can you still hear me?
yes, yes, Judge.
Uh, how long have you been a presiding justice of the Sandigan Bayan?
I've been PJ for the past 7 years, Your Honors.
And you started your career as what? Starting
I
as what?
as as a lawyer, Your Honors.
Yes, you're.
I started my career in law in 1980, Your Honors, right after passing the bar, where I worked in the Supreme Court for almost 2 years. Thereafter, I transferred to the office of the Solicitor General, where I worked for more than 31 years or almost 31 years, Your Honors. Thereafter, I joined the court and I've been with the court for the past 8 years.
By the way, what is your caseload at the Sandigan Bayan?
At this time, Your Honors,
Your present caseload.
um,
Yes, please.
I don't have the data with me right now, Your Honors.
Is this correct? 995 with the average monthly disposition of 6.69 per month.
Yes,
Is
Your
correct?
Honor. Yes, Your Honors. Yes, Your Honors.
Areta, how have you embodied the principle of integrity in your entire legal career? Because we have records of yours starting in 1995, but the alleged grave misconduct filed by Fact-Finding Intelligence Bureau or a disbarment filed by certain Violeta Meneses, and lastly, with the undocketed anonymous complaint filed on March 25, 2019, requesting for an investigation alleged falsities in your PDS in connection to the application for Associate Justice of the Supreme Court, not to mention the numerous oppositions files against you. By the alleged concerns and the Gambayan employees. We have this also the KKK. Even requesting for investigation of the hiring of Blue Guards in Sandigan Bayan, which did not. And we have also a letter from a certain attorney A.L. Bitangol in an email dated September 16, 2020. The oppositor said that he would have sent a detailed opposition against your good self's application for the Associate Justice of Supreme Court position, but deferred the same upon the finding out that you were not included in the short list. So again, I reiterate the question of how have you embodied the principle of integrity in your entire legal career, despite the alleged negative feedback and complaints oppositions against you for this position?
Yes, Your Honors. Your Honors, I have served the government for more than 40 years. I served in the Supreme Court for almost 2 years. There was never any complaint of corruption against me. I worked in the office of the Solicitor General for almost 31 years, and and I served under different Solicitors General, beginning with Solicitor General Mendoza, and they can all attest to the fact that no singular complaint was ever filed with our office regarding any attribution of corruption against me. This anonymous complaint that was filed against me sometime, I think, in 2018 by the so-called, may I just refer to my records, Your Honors?
Yes, please.
Um, by the alleged or letter dated March 5, 2018 of concerned Sandigan Bayan employees relative to the actions of myself. This was, I was required actually by the Supreme Court, Your Honors, to submit my comment. And I did. And after due deliberations, the Supreme Court issued a resolution dated July 17, 2018, dismissing the case outright because according to the Supreme Court, there is no factual and legal basis for the said complaint, Your Honors. In fact, the Supreme Court made reference to the official na pahayag dated April 4, 2018 of the Sandigan Bayan Employees Association members denying that they had any participation at all in the preparation of that letter and the sending of that letter. And they disclaimed authorship of the same letter, and which the Supreme Court found dubious, Your Honors. With
About with this corruption KKK?
yes, Your Honors. Yes, Your Honors.
Yes, please.
Actually,
Position letter received.
I submitted my
This was February 14, 2000.
yes, Your Honors. I submitted my my comment to the Honorable Counsel regarding that regarding this this letter, and where I denied and still deny that I had committed any wrongdoing.
All right.
With respect, Your Honor.
You've been the presiding justice. Yes.
Yes, Your Honors. The letter.
Please continue. Sorry.
The letter dated March 1, 2019, alleging falsities in my answers to questions 25, 26 of my PDS. This was also the subject of my letter to the Honorable Counsel, explaining again the absolute falsity or the lack of a factual foundation or legal basis for the said claims, Your Honors. With respect, Your Honors, to the
How about this? Who is this attorney?
with respect, Your Honors, to the letter
Yes, please
of
continue.
Attorney
Sorry.
Tangkol, I was furnished actually a copy of his letter, and I simply submitted to the Honorable Court decisions penned by the third division or promulgated by the third division of this court, convicting Mr. or Attorney Vitangkol of some of the cases that were filed against him before the court.
Some of the cases filed against him.
Yes, Your Honor. Al Vitangkol, he used to be, I think, MRT General Manager, Your Honors.
I see.
In fact, I was not the ponente in that case, Your Honors, and supposedly I am guilty of gross ignorance of the law, but there is nothing that is said in that in letter of his. But as we all know, Your Honors, I don't decide singularly. We act collegially, and the whatever decision we promulgate is the collective action of all members of the division, Your Honors.
And you have been the presiding justice of Sandigan Bayan for almost 7 years. Can you describe your leadership style?
Your Honor, Your Honors, I would describe my leadership style as leadership by example. I always, since I joined government, Your Honors, I've always been guided by the principles of honesty, integrity, diligence, or performance of work with due diligence, and everything that is required of a public servant.
And how do you move or steer people in the direction you wish?
Well, I conduct dialogue, Your Honors, with my colleagues, particularly during our en banc meetings. We have our discussions, or if there's no en banc meeting, we have a meeting, and the same is true with the other officials and employees of the Sandigan Bayan.
And how do you gain their respect?
First and foremost, Your Honors, is I extend them respect. As they say, love begets love. And I ask for their suggestions, comments on matters that concern the court, Your Honors. I do it on a consultative manner.
What changes have you made in working with others to be more effective work?
I have learned to listen more, Your Honors, instead of simply do the talking. I listen.
All right. What have you done professionally that is not an experience you would want to repeat?
I cannot think of anything, Your Honors.
All right. It is important for a magistrate or lawyer to always maintain his her legal acumen to be effective. How do you keep yourself updated with recent laws and jurisprudence, as well as current issues?
Well, I read the recent decisions promulgated by the Supreme Court, Your Honors. I also listen to the news and read news from online, Your Honors.
All right. In a recent case, the Supreme Court maintained that strict adherence to the doctrine of hierarchy of courts also proceeds from consideration of due process. What was the explanation of the court in arriving at this conclusion?
I think on that aspect, Your Honors, is it refers to the fact that cases should be tried and heard by the lower courts first, so that the parties will be given every ample opportunity to present to present and ventilate their respective claims, so that justice may be properly dispensed.
All right. In another case, simply particularly in COA disallowance cases, if the notice of disallowance is upheld, can the payees invoke good faith so as to excuse their liability to return?
Your Honors, the Supreme Court has quite recently promulgated a decision regarding disallowances of benefits that were given by a certain local government unit. Good faith by itself of the recipients will not exonerate them from paying back or to pay back or to return the amounts received, because according to the Supreme Court under the ponencia of Justice Kagiwa, if these recipients or passive recipients, although they have acted in good faith, are allowed to retain these amounts, it will violate the principle against solutio in debeti, or the principle of unjust enrichment, Your Honors.
Let's go to another. Respect to criminal cases, this is your comfort zone. And being a trial justice in the Sandigan Bayan. Simply, a certain accused was charged with a crime of rape. He, however, moved for requisition of the information on the ground that under the Indigenous Peoples' Rights of Act, or IPRA, the criminal case filed against him shall be resolved first through the customary law or practice of the indigenous group where he belongs. Is this contention correct? It's another recent case, October 2020.
Your Honor, in a recent ruling, as you have mentioned, Your Honor, ruling of the Supreme Court, such a contention is untenable, because the IPRA law simply, what that IPRA law contemplates is the settlement of disputes among the IPs or the ICCs, Your Honors. It does not contemplate settlement of criminal cases.
All right, my last question with respect to psychological one or analytical one. Listen carefully, Justice. Are you tired? I'm sorry. All right, a man condemned to death has the option of picking one of the three rooms. The first is a furnace filled with feeding flames. The second has armed men with loaded guns. And the third has lions starving for years. Which one should the man choose?
I would suggest that he take number one, Your Honors.
The first is the furnace filled with feeding flames.
Yes, Your
Why
Honor.
did you choose the first one?
Because it's just like that is akin to what is being practiced now, Your Honors. In Senate, I forget. When a person dies, it's either he's physically buried in a cemetery, or the family, or maybe in his will he can say that he will be burned or incinerated. I forgot. I'm sorry, Your Honors. I forget.
At least cremation.
Cremation.
Simply cremation.
Your Honors. So to me, that would be tantamount to cremation, Your Honors.
Di nakatipid pa, di ba? Anyway, thank you. That was my last question. Then good luck again. I hope
Thank you very much, Your Honors. Thank you.
Good luck to your journey.
Thank you. Thank you.
You're welcome.
Thank you very much, Your
Yes, I'm
Honor,
done.
Judge Ilaw. The last to interview Honorable PJ Tan is none other than our Chief Justice and ex-officio chairperson, Honorable Diosdado M. Peralta.
Thank you, Attorney Ann. I have to conduct interview. Can you hear me? No? Can you hear me, PJ?
Yes, Chief. Good afternoon, Chief.
Yeah. I had to conduct the interview because I was not able to ask you questions last time. At that time, I think I was not yet a Chief Justice when at that time. So anyway, I was quite busy at that time, so I was not able to ask you some questions. But I would just that to be clarified, because these are the issues that are always raised against you, no? So that everybody can be clarified about all these cases that are filed against you. So I will just ask some questions for clarification because of the question of Judge Ilaw, no? Now, there is a case where you were allegedly charged and then you were found liable for something. What was that case all about? But it was reconsidered. Did I get you right? Is that what I understand? There was a case filed against you, and then the ombudsman found you liable, but an motion for reconsideration that was reconsidered
No, there was yet no finding of liability, Your Honors.
at that time. So what was that resolution then of the ombudsman? Because that is always those are the issues that are crop up every time that you are interviewed and every time that we have deliberations.
Yes, Your Honors. To my recollection, Your Honors, it was a matter of preventive suspension.
Oh yeah, okay. So that preventive suspension arose out from what case? Because the impression of the others for their clarification is that this was a penalty imposed. That's the reason.
It was a penalty, Your Honor. It was.
Yeah, that's correct. But you were preventively suspended for what acts? And what was that particular act that you allegedly committed that led to your preventive suspension?
I was not actually preventively suspended, Your Honors, but there was an order of preventive suspension to which I filed a motion for reconsideration.
Yeah. Okay. Yeah. So
that preventive.
yeah. Okay. So I hope our other members are listening, no? Because when I joined when I became the Chief Justice, these are the issues that always crop up. So there was an order for preventive suspension.
Yes, Your
But
Honor.
that was not effective.
Yes, Your Honor.
Because you filed a motion for reconsideration.
Yes, Your Honors.
Okay, that is and that is clear, no? Okay. So there was no penalty imposed. So my next question is, for the benefit also of the others, what was that case
Yes, Your
that
Honor.
led to the order for a preventive suspension?
Yes, Your Honors. I was charged together. There was a complaint actually filed against me together with some officers of the National Power Corporation at that time.
Okay, so
And
yeah.
supposedly we conspired in the execution of a compromise agreement.
Yeah. And what was that compromise agreement all about? You see, Judge Ilaw is listening intently because they are always asking about all these cases. So let us be clarified so that next time around, probably everybody will be clarified. The next time around, and then you will apply. I hope you get this position now, the vacancy, para hindi na ulitin. Yes.
Yes, Your Honor.
What was that compromise agreement? And who were these parties who entered into this compromise agreement? Yeah.
I'm sorry, Your Honors, I cannot. But they are officers of the National Power Corporation.
No. What was that compromise agreement that was entered into?
It was about. It's an expropriation case, actually.
Yeah.
Yes, it was an expropriation case, and there were efforts to enter into a compromise agreement.
With whom? With whom?
Between NAPOCOR and a party to an expropriation case.
Yeah. So she doesn't. Okay. So go ahead.
So NAPOCOR wanted to enter into a compromise agreement. So they sent a draft compromise agreement to the OSG, and we reviewed that a compromise agreement. We returned that to the NAPOCOR because we found that the provisions in the compromise agreement were grossly disadvantageous to the government.
Yeah. So what happened? What happened with the compromise
So
agreement?
we suggest in that same letter, we suggested that the amount should be that to be paid by the NAPCOR should be less than what is demanded by the property owner.
So it was not consummated.
No, Your Honors, it was not
Not
consummated.
consummated, yeah.
But there was a second draft that was sent to the OSG. This time, the property owner reduced the amount of the just compensation. So this time, the OSG agreed, provided that the compromise agreement and any payments in relation thereto can only be made after the approval of the compromise agreement by the court. But it turned out, Your Honors, that the NAPOCOR on its own, and despite the objection and advice of the OSG, went ahead and paid without awaiting the approval of the trial court.
So, on a motion for reconsideration, you were exonerated.
Yes, Your Honor.
What happened to the officials of the NAPOCOR?
I lost track of it, Your Honors. Because I went on my own. What I know is they also filed a case, but I lost track of it, Your Honors.
Okay, so we are not clarified on that. The other one that they are is about, yeah. Although this was dismissed, but because this is new to me. I do not know about this employment of blue guards. What is this all about? Employment of blue guards.
Your Honors, actually, I responded to that in my.
Yeah, I know. It was dismissed, but you have to clarify because these are the issues that are always raised in our deliberations and in our interview. Because if just merely dismissed without any explanation and what gave rise to this complaint, we are also at a loss. Because if we discuss about you cannot defend yourself, and we are discussing among ourselves.
Yes, Your Honor. So
for us to be clarified.
Yes, Your Honors. Regarding this hiring of blue guards, in my comment, Your Honors, I stated there that the hiring of agency guards was initiated by Mr. De La Cruz, Acting Chief Judicial Staff Officer, Sheriff and Security Services Division, that was in anticipation of the creation of the 6th and 7th divisions of the Sandigan Bayan.
Are you still? Are there still blue guards in your office?
Yes, Your Honors.
What's the basis of the blue guards? Because lately you were requesting for the employment of additional 21 personnel. That's why I'm asking you about this. Do we still need blue guards when we approve 21 additional security officers and utility? Because what I understand from the Sandigan Bayan, we utilize our own security officers. Meron tayong security officers, then sometimes they double as process servers and sheriffs. So my question, what are they doing now? Yung those employees who are supposed to guard our buildings and our properties. Pero separate yan. Yeah.
Yes, Your Honors. They're actually assisting our organic guards.
Yeah. So my question, do you still need these blue guards? Now, how many are they ba? How many are there?
There are 21, Your Honors.
Ang dami nun. 21 blue guards, and how many are organic?
As of this time, Your Honors, I think there are about 12 organic guards or 15, Your Honors.
15 and 20.
Some of the blue guards, Your Honors, are assigned in Baguio, in our Baguio property.
So probably that's the reason why there was a complaint, probably because if you have organic personnel, it's better to recruit organic personnel rather than blue guards, because some will be jealous of employing blue guards instead of employing organic personnel. Baka kaya ganun ang complaint nila. Why employ blue guards when you can fill up? But you have a plantilla for organic. I know there is a plantilla for organic. And I know that during my time, I think there were more than 15 organic guards. So my question is, that's why in my letter to you, I want to have that plantilla because I know that there are organic employees And if you employ blow guards instead of filling up the plantilla, talagang may magko-complain yan. So probably this complaint emanated from one of those employees probably buying to the position of a blow guard where the pay is higher. Because they act also as sheriffs eh. Yung mga organic natin, di ba? They act also as sheriffs eh. So probably that's why we dismissed this one because there was really no basis. But if you look at the plantilla of your office, and then you have a plantilla for organic, but you do not fill up, then you employ blow guards, at talagang may magko-complain yan.
Your Honors, this was actually discussed during one of our unbanked meetings. In fact, Justice Martres was still with us at that time. He was in fact the one who suggested regarding the hiring of
Yeah, but the problem, ano ba eh? Ang problem kasi dyan minsan, when you try to streamline your organization, in the Supreme Court, we have only few blow guards eh. What we do is to have a plantilla for organic employees because your organic employees are under your direct supervision eh. Yung blow guards, when he commits a mistake, or something, he will do something, what you can do is only to report to the office. You cannot remove him. You still go to the head of the order. So anyway, we'll tackle that when we have our meeting about our plantilla. But I have to ask this question also. Probably this was a complaint filed by employees. Eh. They are deprived of being employed as an organic employee when there are vacancies. Yun ang suspicion ko dyan. Okay?
Yes, sir.
Okay. The others, ito bago ito eh. This is my first time to hear about this one. What was this case of involving ano? Ano ito? Case number 404, Barbatry, Forum Shopping. It's about Soldier General Ricardo Galvez. 1101. What is this? Are you familiar with this Meneses case? What's this Meneses case?
Yes, Your Honors. Actually, the complainant in that case was one of the unsuccessful candidates in the medical board examinations, I think sometime in 1996.
Yeah, that's why she's still here. January 10, 2001. Even anyway, this case was filed as early as 1995. So okay. Now I'll go to another question. So I'm clarified about all of this already. So I'll go to another one. No? Now this does not involve your court, but it may, if we do not try to avoid it. Now under the amendatory provision of 10660, you're now allowed to receive evidence, with two. Okay, receive evidence with two. Now, there is a complaint received by me in the JPAS that because of this provision, if there is a vacancy, they do not anymore fill up the third, because according to the law, you are allowed to have a quorum of only two. Now, there is an attempt to question that, because in the law itself, it provides that if there is a vacancy, then the presiding justice, by order of preference, going from the junior to the senior, will assign a third member. Now, the claim of this letter, and the letter is that from the time that there was a vacancy up to the time the decision was rendered, dalawa lang nag-attend ng hearing until the decision, dalawa lang. So the complainant is a government official in fact, because it was filed by a government. So my question is, what do you actually do with this provision that only two can receive evidence? Is it a matter of practice that if one is absent, then you proceed with only two?
No, Your Honors, we still actually require the presence of three, but if there is actually a compelling reason why the third member cannot attend, we go by the authority of the law that and as agreed upon during our embankment meetings, that we can hear the cases with only two members.
In what cases? In what cases do you allow two members to hear the cases? In what cases? Is it an exception or is it a rule?
No,
Or does the law provide? Does the law provide, sir, the instances where two members can hear the case?
no, Your Honors, because the understanding still is that all three members must be present during the hearing.
Yeah, that's correct. But the law allows dalawa nga eh, di ba? Now, in what instances where two members of the Sandigan Bayan can hear the cases without any third member?
When there are no more available.
Okay, when are not available. Yeah, okay. No available, right? And do you consider the reason of the absence also as a factor?
Yes, Your Honors.
So in other words, it is an exception to the rule. It is always three.
Correct, Your Honor.
Yes. And then if the absence is justified, I think that's what I was trying to ask from you. The answer. When the absence is justified, in other words, the law enumerates legal disqualification. Diba? That's number one. Under the law, temporary incapacity of a member or vacancy therein, the presiding judge may designate a member of the another division to be determined. So hindi automatic yun eh. It will still be an order of preference, diba? Or seniority in the assignment of a third member. Okay? Now, if there is no available member, then the two will be allowed to proceed. So,
Yes,
and only in those instances where two members of the court can proceed with the reception of the evidence. That's what the law provides, di ba?
Yes, Your Honor.
Yeah, tama ba? Now, but the absence of the third member, kasi hindi yung temporary, hindi vacancy ito because if it is a vacancy, automatic yan, you have to assign. But if the membership is complete, and there is a justice absent, di ba? How do you consider the absent justice? Absent without leave or with leave or unofficial leave or what? In other words, if I am the member, can I just absent myself anyway? Pwede naman yung dalawa. Can I do that?
No, Your Honor.
Yeah, you cannot do that, right? So the absence must be an emergency absence. In other words, the third member who is not present must be on vacation leave, official business, sick leave, and probably emergency leave.
That's correct.
That's what I learned. So that should be the case, di ba?
Yes, Your Honor.
So the complaint is like this. From the time that there was a vacancy up to the decision, there were only two. So hindi nag-assign ng third member. So sabi ko, you really look at the law, hindi tama yun eh. There must be really a third member because the idea only of the two members, yung instances during my time where the witness is already in Manila and there are only two because the other one is absent, then you can proceed. That was the purpose di ba? So it should not be the rule, but it should be the exception. Only in those cases that you are allowed to hear cases with two members. Hindi pwede, hindi ako available ngayon Pwede ba ikaw muna? Hindi pwede yun. That cannot be done because the law enumerates temporary legal disqualification. That means inhibition, mandatory inhibition, or even voluntary inhibition. Temporary incapacity, that means he's sick, or a vacancy therein. So only in those three instances. So it's merely an exception. Okay. Do you agree with me?
Yes, Your Honor.
Yeah, that's correct. Yeah. But there's now I do not know if they will file a case, but that's the complaint that I received. I do not know if the complaint is correct. I don't know how true is the complaint, but that's the gist of the complaint. Now the other one is this. There is also an amendment as far as handling of as far as cases cognizable by Sandigan Bayan, because there are now cases, even if the salary grade is 27 up, no, 27 up, there are now cases that if there is no damage on the part of the government, or it's not a bribery, even if the salary grade is more than 27 and above, then the case will go to the RTC, regardless of the position and the salary grade. Okay. However, the case should be filed to the judicial region nearest to the judicial region where the crime was allegedly committed, no, subject to the rules of the Supreme Court that may be promulgated later on. I hope, I think you know that, no?
Yes, sir.
Yeah. So, in short, there are not many cases filed before RTC because of this. Like, for example, the disadvantageous to the government. There is no element of damage. If the contract is grossly disadvantageous, it might not go anymore to the Sandigan Bayan because there is no damage is not an element. But what will go to the Sandigan Bayan probably would be causing damage to the government through evident bad faith, because it is required that in order to file that particular violation, there must be an actual damage alleged and proven during the trial. Even giving unwarranted benefit committed by government officials under this provision, no need to prove damage. Only the first part of the 3019, paragraph 3A, 3019, where the amount of damage should be quantified in order to be liable for violation. So in short, and probably that's the reason why there are now few cases being filed before the Sandigan Bayan because of this particular case. Do you agree with me? Kaya sabi nila, si Ombudsman kasi hindi masyadong nagpapel ng cases. Then I discovered later on, because there was a case brought to us under this provisioning. So probably this is one of the reasons why there are now cases filed before the RTC, which should have been filed before the Sandigan Bayan, if not for the amendment. And that is helping the Sandigan Bayan clear your docket or reduce your docket. So this law became effective as early as 2014. Yeah, the amendment to RA 1606, if I remember right, I think it's 2014. This law has been there in 2014. So some of the cases were filed there and therefore could have affected your docket. Now, you have now 7 divisions. You have now 7 divisions, whereas before there are only 5. Because of this provision, we expect that the dockets of the courts will now be considerably lowered. Because those cases that are filed now under the new law, pupunta sa RTC yan, at marami yan eh. In fact, they are inquiring from me. Bakit may RTC dyan? Ikaw basahin yung mandatory provisions. Even Saturday 28, if there is no element of damage on the part of the government of the crime charge, and or there is no bribery, kasi kung bribery talaga sa inyo yan eh. Basta Saturday 27, sa inyo yan eh. Pupunta sa RTC yun eh, the judiciary yun eh. So, my question is this. Has this law really affected your docket and therefore considerably lower the dockets of the Sandigan Bayan?
Yes, Your Honors. We have considerably reduced actually our backlog.
Yeah. Well, I asked that question because, alam mo naman yung program ko to clear the dockets of the court. We have adopted a lot of reform programs, and the executive and the legislative have been also helping us. And this is one tool of helping the courts plug the dockets of the court. So what I wish to convey is this. If we have all these tools, law and the reform programs that we have adopted, I think there is no reason why our docket should be as high as 500. Because in our study here in the Supreme Court, the manageable docket of the RTC, nag-iisa lang yan the manageable docket of an RTC, and his only one is 500 cases. We consider that manageable, but some say, masyadong mataas yung 500. But that's the data that we have gathered, and then we based from the data that we gathered that this is the manageable now. You are 3 in the Sandigan Bayan, and like any other regular trial court, you are also a trial court, but you are three. And there is the law that if one is not available because of incapacity, then you can proceed with the hearing if there is no available justice to take over the temporarily incapacitated. Yan. So, my question is, kasi meron dyan sa isang division yan, not actually proud to say, but they always say, oh, based on our records, wala kaming pending. But of course, I do not challenge them. In fact, I'm very happy to hear that. But yun ang isang reason because of the law and the reform program. So in your end, I think yung 900 cases in a division, I think that's too much. Sa akin lang but I'm not blaming you, because there are many reasons why, especially presenting justice, you do a lot of administrative work. Alam ko yan But in your distribution of cases, yung dalawang members mo, meron may proportionate assignment of cases in the equal distribution yan. So my only wish is that with all this reform program in this one, pwede ba you come up with to me so that if you become a justice of the Supreme Court, whoever will take over from you, she or he will follow what you have implemented to reduce the docket.
Your Honors, may I respond? Yes, this the cases indicated in our docket, specifically in the 3rd Division, these are actually cases, or most of them are cases that are still pending trial. We have very few, maybe about 5 cases that are submitted or have been submitted for decision. We have tried our best actually to comply strictly with the revised guidelines on continuous trial. And actually, Your Honors, most of the cases that, or a big number of cases pending before our division is already the stage of the presentation of the defense evidence. And these cases could have been submitted for decision last year, were it not for this pandemic.
I know that. In all, but this is the extraordinary situation yan but of course we have adopted also measures to address the pandemic. In fact, we are very lucky because I took the initiative to approve your video conferencing even before we approve the video conference that's applicable to all. Inuna ko sa inyo because I know that you need it because we were aware of the dockets of the court, and then it was really very hard to conduct trial in Sandigan Bayaran because you are 3. So pag nag-video conferencing ka and then 3 justices are residing in different places, mahirap yun. Unlike kung nag-isang justice, but at that time kasi it is easier for us to adopt a video conferencing in your end because your jurisdiction is national in character. Wherever you are, you conduct the trial Kaya sabi ko, unahin natin sa Sandigan Bayan because meron silang ganitong pending nila, then it's very hard to come up with a video conferencing kasi 3 different places yan. We will have some problems, technical problems. Sabi ko. Unlike in the RTC kasi, there's a problem of jurisdiction because you cannot hold trial outside your territorial jurisdiction. Kaya inuna namin yan because we are aware of the problems in the Sandigan Bayan. Now, what I'm trying to convince is this, we have 7 divisions sa Sandigan Bayan. And then you have additional lawyers. I think you have, how many lawyers? Additional lawyers?
The associate justices have 4, Your Honors. I have 5.
Yeah. Before, we have only 2. There are 2, and we were only 5 divisions. So, and with all these tools, 7, with all these tools, I think there will be a better performance. We expect a better performance because we did not have this one before. And then at the time when I joined and then I think you're aware, when I joined the court in 2002, I think 90% of the PCCG cases were still pending before us, and there were a lot of them. I think you're aware of that because you used to appear before us pending PCCG cases. And those are the cases that really burden us a lot. May criminal cases, wala pang itong batas nito, wala pang continuous trial, And then we have a lot of PCG cases, ang tatagal yan, but we were able to reduce the number of cases through probably innovations, which I adopted. Wala pang continuous trial rules dyan. Nag-implement na ako ng ano yan, ng direct testimony, adapting the affidavit through stipulations nun. Kaya mabilis kami nun. Wala pang continuous, but we adapted with Justice Ponferrada as my senior, and then Justice Alex as my junior. Then later on with Justice Efren as my senior, and so on. So my only wish, because of all this, you have additional lawyer, you have 7 divisions, we have this law, we have continuous trial criminal cases, you have your video conferencing. All of this, sa tingin ko, even if we have this kind of pandemic, I think we can do something in order to reduce the docket. Di ba?
We will certainly do that.
Yeah. Okay. Thank you for that. Kasi, alam mo naman, one of the programs I had, I will be leaving very soon. And I want to leave something that can be remembered. I can be remembered. Di ba? And these are the things that I want to be improved before I leave, to reduce the dockets of the court. I hope your colleagues are listening. To avoid any misunderstanding. Sometimes, pag kinapura mo sila, then daming, human nature, di ba? Tell them to go like this, we are already doing our very best, and so on. That's not the point. The point is, we have to do something in order to reduce our dockets so that people will have faith in the court. So, my last question is, I was reading your essay, and one of the points that you raised or you address is whether or not the 24-month provision in the Constitution is mandatory or is directory. Of course, we as members of the court, we will agree. We are happy to say that this is directory because marami talaga more than 24 months. If that is the interpretation, most of us will be very happy because really we have a lot of cases talaga. It's not only judicial but administrative. And then you have also your rule-making committees. Marami talagang administrative dito na trabaho. That's why people say, 24 months lang kayo. That 24 months refer to judicial matters. But we do not only attend to judicial matters. Ang dami yan. Ang administrative. So, if this is directory, as you opine, because probably you read one of the columns of our retired justice, because he himself also, everybody has problems with the 24 months. Like if you are a member of several committees where you have to work weekly to attend to the concerns of that committee that you had, talagang mahirap yun. Kasi dalawang trabaho namin dito So, my question is this, assuming that you are correct na directory yun, and there are so many cases that are actually filed before the court. Now, do you agree with me that there is a need to amend some of the rules so that probably cases will be acted faster or cases shall be limited? My colleague was asking about the case penned by Justice Hardilesa, I think, the case of Samar, where he said that the hierarchy of courts, a violation of the hierarchy of courts should be a ground to dismiss the case because you did not file the case before the court where it has concurrent jurisdiction over that, no? So, ano atang magandang gawin in order to address this one? We have been trying, but how to get rid of this hierarchy of courts, meron yung dismissal, discretionary appeal under Rule 45 and so on. Marami. But still, marami pa rin cases ang dumarating I think we have both administrative and sa tingin ko, more than 100 every month for each Unless the mga 65 to 100 cases every month ang dumarating. It's justice So if you can only resolve 50, di meron kang pending ng 50. When you retire, inherit, ganun ang dami. So, ano atang magandang gawin sa rules in order to address this problem? Even assuming that the 24 month is directory. PJ.
Well, as I have said in my written exam yesterday, Your Honors, I think you mentioned it already. Maybe the court should be more stringent in when it comes to when the suits availed of are petitions for review on certiorari. That the court should stick to the rule that it can only entertain such kind of petitions where only purely questions of law are raised, and the court will no longer entertain petitions which also raise questions of law.
Ang problema doon may dismiss.
Rather.
Yeah. Mag-dismiss, but they still file petitions. So it will still go back to us, even if we dismiss it outright, file pa rin sila ng petition for Rule 45. It's not really a question of how you resolve them, but it's a question of every now and then, even they know that it should be dismissed pa rin sila ng dismiss, and then sometimes they argue, I thought that the Supreme Court is a court of last resort. That's what they argue, so we dismiss it. Probably you have read about cases filed regarding that about the COVID, where they wanted to be released, even without going to the process of hearing a petition for bail.
Yes.
Then we said that no, you have to go to the lower court and then address that. You see, what were they saying? Oh, akala ko, court of last resort, this is extraordinary. You should have already, there's so many things. So, is there something that we can do that if a petition for certiorari under Rule 45, there is a question of, or they raise issues of question of fact, can we say, do not file this kind of petition or else you'll be cited for contempt against the lawyer? Can we do that? Wala kasi. Can we do that?
Well, Your Honors, the Supreme Court has awesome powers when it comes to disciplining lawyers. So, sometimes the Supreme Court states in its resolution that no further pleadings of the same or motions of similar tenor will...
Iba yun kasi no further pleadings is that we already stopped, so that the case already submitted for resolution at saka judgment has already made. This one is initial petition So anyway, that's one of the, probably when you join the court, you can make some suggestions. What I was thinking before is that the case should end before the Court of Appeals. If it is a case, for example, and that's what we did with the small claims, I don't know if it is viable or it is acceptable, that if a case is tried by the first level courts, like for example, ejectment, all those cases covered by the rule on summary procedure, if the findings of facts by the first level courts sustained by the RTC in toto on the finding of facts, then the finding of facts of the RTC should now be final. So the remedy of the losing party from the RTC to the Court of Appeals is only Rule 65. Therefore, he can no longer file a petition for review in order to review the question of the finding of facts of the RTC because final yun Kung final yun, then only remedy is Rule 65. Pag Rule 65, you will only argue that it's grave abuse of discretion. But if you deny the Rule 65, sa tingin ko, they'll have no more remedy going to the Supreme Court. It will end there. I think that will be the time that if they still file a case where the Rule 65 is still in the court, I think that's the time that we can warn the lawyer. There is no such remedy and so on. That's what we are thinking, but there are some also contrary opinions. Sabi naman nila, if it is a Rule 65, madidelay din yan because you can file Rule 65 under certiorari under Rule 65 60 days from receipt. Di madidelay din ng 60 days. So maraming opinions. So these are the things that we have to address and then think about in order that those cases will no longer reach the Supreme Court. That's why I said, I will say it again, kaya ganito kahirap ang trabaho ng Justice ng Supreme Court. It's not only judicial. Yung cases that we are reading, pass through several deliberations yan But the most difficult task of a justice is administrative work because you have to come up with a lot of opinions, not necessarily coming from the books, law books. come from experience, come from best practices, and so on and so on. So I think if we say that the 24-month is a directory in character, good for us. But sometimes, we read also opinions. No, that's not. No, it's mandatory shutdown. So anyway, we will not debate on that. But I respect your opinion. So that is my last question. Just PJ, I hope you will make it, and good luck. See you in the next meeting.
Thank you.
And the Plantilla, we'll have meeting Plantilla and also the creation of a procurement office. We'll have to put topics for the next meeting on January 15 ata, no? Okay, sige. See you then, and then good luck. And Leia, I am already through. Okay.
Thank you so much, Your Honor, Chief Justice Peralta. That concludes the public panel interview of Honorable Amparo M. Kabutahi-Tan. Thank you very much, Your Honor, Presiding Justice Tan. We wish you the best of luck.
Thank you, and thank you very much, Your Honors, to the members of the JBC. Thank you, Chief.
Meantime, I will excuse muna. Kayo na lang muna. I'll just excuse myself. Okay? Thank you Anyway, nakikita ko naman si Noel na eh. Okay.
Thank you, Your Honor. Leia, si Justice Di Maampao.
Yes, ma'am. Admitting po.
Your Honors, the next candidate to be interviewed is Honorable Court of Appeals Justice Japar B. Di Maampao. Good afternoon, Your Honor, Justice Di Maampao. Honorable Justice Noel Jimenez Tiham will have the first crack at interviewing you. Your Honor, Justice Tiham, please.
Thank you, Attorney Ann.
Welcome, Your Honor.
Justice Japs.
May we ask the Honorable Justice Di Maampao to unmute your audio, please, Justice? Thank you, sir.
Good afternoon, Justice Japs.
Good afternoon to you, Your Honor.
All right. You are 56 years old, but I think you grew older inside the JBC interview room, correct?
Yeah, I confirm that, Your Honor.
How many years have you been interviewed by the JBC?
What I recall, as far as I can recall, Your Honor, I applied 13 times and I was, by God's grace, shortlisted 13 times.
So you were in your late 40s when you applied, or you were already 50 years old?
I was above 50 years old, Your Honor.
50, yes. We have interviewed you. We have interviewed you so many times, and it is useless to repeat the same questions all over again. So my only question, Justice Jap, is this: what kind of a Supreme Court justice will you be? Will you be a team player, or will you be a reformer?
Your Honor, I adhere to the principle of judicial collegiality. It finds a basis in the Constitution, Article 8. It proceeds upon the theory that there is only one Supreme Court. The Supreme Court renders decisions based on the collective opinions of the justices, and as defined by authorities, judicial collegiality consists in the relation a relationship among equals in rank, and usually carries positive connotations of cooperativeness and joint efforts toward achieving appropriate aims, operations, and functioning of the court as an institution.
But that's not very reassuring. In effect, you're saying you will be the same of the same. There will be nothing will change, you're saying, in the Supreme Court if you join the court, because
I,
you'll be a
I
team
will,
player,
I
and
will,
you're a team player, you will do and follow whatever the bank says should be done without stifling
I
your
will,
own innovations and reforms? Is that what you're saying?
I will always uphold the supremacy of the Constitution, and I will likewise be guided by the definition of judicial power under Article 8, Section 1, Paragraph 2, which in effect adopts the theory of judicial activism.
Judicial activism. You will uphold the Constitution, you said. The Constitution says justices of the Supreme Court must or shall resolve cases within 24 months. Will you uphold that provision?
It's quite clear, Your Honor, under Article 8, Section 15, that the constitutional mandate uses the word must. So must connotes mandatory. It says must be decided or resolved within 24 months, Your Honor.
So if a colleague of yours in the court, in the High Court, refuses, neglects, or fails to decide a case within the constitutional period stated, what will you do? Will you say nothing? Will you tolerate that omission?
I leave that to the court in as much as that there may be appropriate sanction as provided for in the Article 8, Section 16, in case of failure to comply with the 24-month prescribed period for the redemption of such decision, Your Honor.
So what will you do, Justice Job? Will you just keep quiet? Will you call the attention of the Chief Justice? Will you call the attention of your brethren in the High Court?
There is nothing wrong in calling the attention of my colleague.
You're not answering my question. Will you call the attention of your brethren in the High Court?
Yes, Your Honor. Inviting his attention to that constitutional provision set forth in Article 8, Section 15, Your Honor.
Are you in favor of reviving the Ethics Committee in the Supreme Court?
Yes, I am in favor of the revival of the Ethics Committee in the Supreme Court to strengthen the integrity of the Supreme Court and eventually define the course of judicial excellence in this country.
Do you adhere to the principle that the standard of competence among magistrates in Philippine courts should be the same without exceptions, without discrimination?
Yeah, it should be uniformly applied without discrimination, Your Honor.
In other words, if lower court judges, if appellate court judges neglects to decide cases within the reglementary period, a statutory period, and they are penalized, the same standards of responsibility and consequence should similarly apply to members of the Supreme Court. Do you agree with that statement?
I agree, Your Honor, so as to uphold the equal protection clause under the Constitution, which mandates equal treatment, in
All
this
right.
case, among magistrates.
Justice Jupp, I have known you, you're qualified, but so are the others applying for the position. They're equally qualified. But speaking about yourself, will you be an asset to the court? And will you be somebody different from the others who are applying? Aside from the fact that you're a Muslim brother.
With all humility, Your Honor, I can bring to the court my integrity and my wealth of knowledge and experience as former.
Let me cut you on that. We do not, the court does not need magistrates of integrity because there are already magistrates of integrity in the High Court. What the High Court needs are productive, hardworking magistrates. Are you a productive, hardworking magistrate of integrity? Because all of the members of the High Court are people of integrity. But are you a hardworking, diligent magistrate?
With all humility, Your Honor, yes, my case disposition and the Court of Appeals speaks volumes about my.
How many cases do you dispose on a monthly basis on the average?
I dispose cases on a monthly average 13 to 15, as I am very particular about the quality, Your Honor.
But you are expected to dispose of no less than 40 to 60 cases a month in the Supreme Court. Do you agree that the principal problem in the High Court is the congestion of the court docket? Do you agree with that?
Yes, Your Honor. In fact, the Supreme Court recognizes that in the case of U. Samar versus DOTC.
So, there's congestion, just like traffic. You either solve the congestion, you either solve the traffic by building a bigger highway or by limiting the number of cars entering the highway. How would you apply the same figuratively in the High Court if you become a member of the High Court? How will you, what practical solutions will you give to decongest the court docket?
First, Your Honor, I will adhere strictly to what the Supreme Court said in the case of U. Samar versus DOTC.
So you will just follow what the Supreme Court said. You will be a follower. You will be a team player. You will not be a reformer at all.
I likewise, Your Honor,
Be a reformer. You have to set an example, correct? You have to work diligently so that if you are diligent, you are productive, and your brethren in the High Court sees you like that, then you'll be setting an example and they will follow you. Isn't it?
Yes, Your Honor. I agree, Your Honor.
So how will you expedite? What reforms, what new ideas? Many ideas have been broached, but what new ideas, practical ideas, doable ideas, will you suggest to the bank to decongest? Can you give specific examples?
Your Honor, there are cases that involve complex or complicated issues and that may cause delay. So I may respectfully propose that these cases involving complicated issues may be referred to a justice who is knowledgeable about the same. And in
Is
that
it
way,
important? May I just cut you, Justice Jeff? Is it important, first of all, to indoctrinate again lawyers and litigants about the judicial system? I pose that question because I'd like to ask you a sincere question. Do lawyers want their cases to be resolved immediately? Sincerely.
no, Your Honor, they are after
You were in law practice before, correct? Before you joined the judiciary.
Yes,
So
yes.
what was the orientation of lawyers? Were lawyers taught in school? Were lawyers trained to decide to handle cases, to litigate cases as fast as possible? What is your opinion? Were they trained like that?
They are really trained to
Collect fees, correct?
Yes. That's just secondary, Your Honor, because lawyers should always uphold the attorney's oath
Yes.
to handle the case.
That is the ideal. That is the ideal situation. But do lawyers really want their cases to be finished as soon as possible, at the risk of losing their source of livelihood and source of income?
That may be one of the considerations as they may expedite the collection of their fees, but they should always remember their oath as lawyer. Just attorney's fees is just secondary, and they must always be a partner of the court in the administration of justice, such that they should always look for such fair and just decision. And to be fair, just decision must always be rendered based on merits, applicable law in effect, and applying the prevailing jurisprudence, Your Honor.
Is there a need to orient also litigants and the public in general that it is imperative that cases should be resolved immediately so that relief can be granted to the aggrieved, to the victimized? Is it important that?
Yes, it is important, Your Honor, because no less than the Constitution has set it, Article 3, Section 16, that every person shall have the right to the speedy disposition of their cases before the quasi-judicial, administrative, or judicial courts.
Why is it, Justice Jupp, that people are willing to accept the finality of a decision only after the Supreme Court has acted on it? Is it because of the common belief that the Supreme Court is the final arbiter?
There is such thing, Your Honor, as immutability of decision. So once the Supreme Court has rendered decision following what the Supreme Court said in the case of well, in one case, the open quote, the Supreme Court by tradition and in the judicial administration of justice has the last word on what the law is. It is the final arbiter of every justifiable controversy.
Is that a reassuring statement? In effect, does that statement say that lower courts' decisions should not be respected because it is not the final say on the matter?
Let me quote what the Supreme Court
In
said.
other words, litigants should not accept with finality decisions of lower courts because it is not until the Supreme Court has a final say that it has legal effect and it becomes legally binding. Is that what justice is all about?
Your Honor, the parties have the right to appeal the decisions of the lower courts to the RTC, Court of Appeals, eventually the Supreme Court. And the Supreme Court, the lower courts take their bearings from the Supreme Court, Your Honor. Since the decisions of the lower courts are appealable eventually to the Supreme Court, it is, as declared by the Supreme Court, it is a decision of the Supreme Court that may be rendered final, it being the final arbiter of any justifiable controversy, Your Honor.
So if people are willing to accept only the decision of the Supreme Court, why not abolish all of the other courts and just create one Supreme Court with about 2,000 justices of the Supreme Court distributed nationwide? So it becomes only one Supreme Court. Why create the hierarchy of courts if justice is only available after it reaches the high court? Why create the hierarchy of courts? What is the purpose of that?
The purpose of the hierarchy of courts is for the lower courts to first resolve cessation issues, and cessation issues or decisions on cessation issues may be.
So lower court judges are staffed by judges of lower caliber. Is that what you're saying? Then the appellate court magistrates are staffed by appellate magistrates of higher caliber, and that it's only when it reaches the Supreme Court that it becomes totally acceptable by the public. So my point is, there is no logic, there's no rationale. If people will only believe a decision rendered by a Supreme Court, why create a hierarchy of courts? Why not just create one Supreme Court composed of 2,000 magistrates distributed all over the Philippines, and that the decision will become final and executory? Does the hierarchy of courts serve a purpose for that? Does it serve the ends of justice? If the decision will ultimately be reviewed by a higher court and by another higher court, does it serve the ends of justice?
Yes, Your Honor, serves justice as they are.
It is a systemic sense of injustice by creating a bureaucracy of delay, is it not? You're creating a bureaucracy of delay by creating many courts if people are not willing to accept the decision of a lower court as final, as binding upon the parties. Which goes to my last question is this, Justice Jobs. Lawyers know the law, correct? They are
That's
familiar with the decisions of the Supreme Court. But how come lawyers repeatedly file petitions which are not meritorious, which has already been decided similarly by the Supreme Court? Why go through the process of repeating and refiling cases if the Supreme Court has already decided on the matter?
the reason that they can pursue that they may be after the collection of their attorney's fees. And to my mind,
That's the first sensible statement you made in this interview. Anyway, Attorney Jeps, I know that you're qualified, but you should be aware. And the Chief Justice has repeatedly stated this, the problems confronting the High Court. We don't need qualified, intelligent magistrates in the High Court. We need qualified, intelligent, honest, hardworking reformers in the High Court. All right, that is my last question, Justice Jap. Thank you, and I hope we don't see each other again in another interview before the JBC. Thank you and good luck.
Thank you, Your Honor. Thank you so much, Your Honor.
Thank you very much, Your Honor. Justice Tiham. Honorable Judge Toribio E. Ilaw Jr. will now take his turn in interviewing Justice Lim Ampao. Your Honor, Judge Ilaw, please.
Yes, thank you, Attorney Yan.
Welcome.
Yes, Justice Jap Lim Ampao, how are you today?
I am good, Your Honor. Thank you.
From the remark or observation of Justice Tiham, you grew older. And how many times have you been to the, interviewed for Associate Justice of the Supreme Court? We started July 23, 2010.
But since I applied under this administration 13 times, it's not accurate to say that I was interviewed 13 times because there were instances wherein my interview was valid for 1 year, so I could not exactly say the exact number of interviews, or but it may be less than 10 more or less.
10 or more or less interviews. But you were previously nominated to the Supreme Court as an Associate Justice twice in 2019, twice in 2018, twice in 2017, twice in 2016. Now, what do you wish someone would ask you? What do you wish someone would ask you from that premise of so many nominations as to the position of the Associate Justice of the Supreme Court? Why? Simply, why are you not appointed?
I firmly believe in the appointing power of the president. I respect that. It's only the president who knows the reason in the exercise of his appointing power. Your Honor, allow me to say that I applied again for the 14th time because of my firm belief and conviction in these two Quranic injunctions. First, God, indeed God is with those who patiently persevere. Second, God is the final disposer of affairs. Likewise, Your Honor, I find optimism in the old saying, hope springs eternal. So, in the fullness of time, God will grant one's prayer.
Because I still remember the song In the King and I, Yul Brynner, that was in the early 60s. What is a puzzlement? What is a puzzlement? That is the Pandora's box of nagging question that's been pried open. That one has to large sway. Why are you not appointed?
I
Anyway, you have already answered the question. At any rate, by the way, what's the complete name of your wife? Sita Maria Gina V. Di Mampao.
Maria Gina.
What's her middle name? What's V?
Villapani.
Villa
Pani, Your Honor.
Villapani. Okay. And that reviewing the records that you've been a lecturer for 20 years, RTC Judge Branch 208, Mandaluyong for 3 years, been a prosecutor for 7 months, court attorney, political affairs assistant, legislative staff officer. But simply, your promotion to the judiciary has been fast. Am I correct?
Yes,
you only
Your Honor.
spent 3 years in the regional trial court, then culminating for your promotion as an associate justice of the Court of Appeals.
I served, if I remember right, Your Honor, almost 4 years in the regional. More than 3 years, Your Honor.
And what are your priorities in life?
As magistrate, I always uphold the oath of a magistrate. Of course, my family and that of my desire to help the needy and the impoverished.
All right, you're presently 56 or 57 years old because you were born on December 27, 1963. You're still young, 57 years old. And if you're going to be appointed as an associate justice of the Supreme Court, you will be staying for 13 years in the Supreme Court. With a cliche, I'm not going to be bored. For 13 years, you're just going to work, and work, as the saying goes.
No, Your Honor. On the contrary, I will find it fulfilling because we will be contributing to the just and speedy administration of justice in this country. It is fulfilling and rewarding, Your Honor.
All right, what is your caseload at present?
I think I have only 35 more or less cases submitted for decision, Your Honor.
But in our record, it's 435 cases.
That cases are for completion, Your Honor. For completion. It's, with all due respect, Your Honor, different from those cases submitted for decision.
And desultory skimming of the record of cases or administrative cases filed against you, we have 5 cases. What was your feeling the first time you were called upon for alleged gross ignorance of the law? Almost all of the cases filed against you.
With all due respect, Your Honor, I think that there were only two administrative cases, and these two were dismissed by the Supreme Court. The court decision on these two cases has been declared with finality, and the respondents are warned not to file further motions for consideration. So these were all dismissed, Your Honor. These were baseless, as they were in effect disgruntled parties or litigants. We applied the law, applicable law, and jurisprudence of these cases, and that must be the reason why the Supreme Court dismissed these two petitions, these two complaints against me, Your Honor.
Let's start with an administrative case filed against you in 2009 for alleged gross ignorance of the law, dishonesty, and gross misconduct filed by a certain attorney Eligio Malyari, though it was dismissed and no further pleadings will be entertained. The second one is a gross ignorance of the law, dishonesty, and gross misconduct filed again by a certain attorney Eligio Malyari on December 5, 2016, though it was dismissed. A third one, gross ignorance of the law and violation of Canon 3.01 of the CJC filed by Advocates for Excellent Government, represented by Jose Maria Mirasol on March 5, 2018. And lastly, the gross ignorance of the law, alleged gross ignorance of the law and violation of the canon of the Code of Judicial Conduct filed by Advocates for Excellent Government, again by a certain Jose Maria Mirasol. That was on March 5, 2018.
With all due respect, Your Honor, those two were related cases. As you can readily see that the petitioner is the same, Attorney Malyari. Likewise, the last two are related cases, as the petitioner is also the same. So in effect, Your Honor, there were only two. And the Supreme Court dismissed these cases with finality.
All right, Canon 2 of the Code of Judicial Conduct states that a judge should avoid impropriety and the appearance of impropriety in all activities. How have you embodied this requirement?
I always imbibe that in the discharge of my judicial duties, as I avoid any appearance of impropriety. I endeavor to exercise my judicial functions, taking into consideration one decision of the court regarding the qualities of good magistrate, and to quote what the court said, a magistrate of the law must comport himself at all times in such a manner that his conduct, official or otherwise, can bear the most searching scrutiny of the public that looks out to him as an epitome of integrity and justice. So I always take to heart this pronouncement of the Supreme Court in that case of Cortes versus Agcaweli.
All right, as a member of the academy, aside from being the magistrate, and you being a bar reviewer and an author of various books and subjects regarding the law, what changes will you effect in the bar examinations as to help law students to become lawyers and address the increasing demand for lawyers while at the same time maintaining or improving the quality of lawyers in this country produces?
There are reforms that may be instituted regarding the conduct of the bar examinations. The subjects, which are now 8, may be reduced. For instance, as proposed, taxation and labor law may no longer be regular bar subjects. The provisions on remedies may be incorporated in remedial law. Regarding labor laws, the provisions of the Constitution on labor law may be incorporated in a political law. There are reforms also that may be inserted given my experience, and these are reforms relative to the command of English language among bar examinees. As bar examiner in 3 bar examinations, I noticed that some of the bar examinees, with all due respect, could hardly express themselves in good English. So since English is the medium of instruction, as lawyers have to use that skill in arguing their case, there has to be a reform to this effect. So those are just some of the reforms that I have in mind, Your Honor. And also, I am of the view that the 2 examiner rule must be maintained just to expedite the checking of the papers of the examinees, and results be released earlier than expected, Your Honor.
But my next question might have been asked in previous interviews, but I'm going to repeat it just for the record. What do you foresee will be your contributions to the Muslim community, which has earnestly supported your nomination to the Supreme Court as an Associate Justice of the said body?
Your Honor.
And how do you intend to realize these intended contributions?
Your Honor, under the BARM Law, Republic Act 10154, Article 10, entitled Bangsamoro Justice, there are provisions there that may require implementation. There is this Sharia court system. I intend to propose, Your Honor, if I will be appointed to the Supreme Court, the revision of the special rules on Sharia courts, because it's ironic that since its adoption in 1983, these special rules on Sharia courts have never been revised. So to the Muslims, they will consider that as a welcome development. And there are also provisions under the BARM law regarding the strengthening of Sharia system in this country. And I think as member of the court, I can be of help in the implementation of such provisions on Bangsamoro justice under Article 10 of Republic Act 11054.
All right, I'm not going to ask you about the recent case you mentioned and been mentioned by previous interviewees with respect to Geos Summer Inc. versus DOTC. you you may have known this and that, but with respect to the recent decision by the court, what are the requisites for the admissibility of a dying declaration? In People versus Mabutas.
It must
elementary. Yes, Justice.
Your question, the requisites of dying declaration, Your Honor?
Yes, Justice.
Premise on the trustworthiness of the testimony as it is made in imminent death. First, it must be made at the time when a person is in that dying state. And number two, he must have communicated such statement clearly and distinctly, and it is made under that circumstances of dying situation, Your Honor.
So in another case, do local government units have inherent power of eminent domain? Local government units, do they have the inherent power of eminent domain?
It has been ruled by the Supreme Court that the local government units have no inherent power of taxation by parity of reasoning. Such local government units may have no inherent power of eminent domain, Your Honor.
Your internet connection is unstable.
All right,
Thank you. Very good answer, Justice.
I must admit, Your Honor, there is internet interruption. Sometimes I cannot clearly hear your question.
Annette, anyway, I heard it, the answer substantially correct. So that my last question, Justice. My last question, what is the most challenging aspect of being you?
May,
What
there
is
there
the
is
most challenging aspect of being you?
to my mind, the challenging aspect is uh, to be a model, a magistrate or a magistrate of the law according to the attributes set forth by the Supreme Court in one case, which I have just stated, Cortes versus Alcaveli. I must, in this regard, echo what I have said in previous interview. As a challenge to me, I will endeavor to personify judicial integrity, epitomize judicial independence, and exemplify judicial temperament, Your Honor.
Thank you. That was my last and final question. Thank you again. Then good luck, Justice.
Thank you so much, Your Honor. Thank you so much.
Thank you very much, Your Honor.
I'm done, Attorney Ann.
Yes, thank you very much, Your Honor. That winds up the public
You're
panel
welcome.
interview
Thank you.
of Honorable Justice Chapar B. Di Maampao. Thank you very much, Your Honor, Justice Di Maampao.
Thank you.